Okay. Ms. Rouse, are you ready?
Yes, sir. I just put it on YouTube.
And very good. And counsel, let me, first of all, welcome to the 95th District Court. Let me address one thing for the record. This is a formal proceeding of the 95th District Court, even though it is being conducted over the Zoom platform to assure compliance with the open courts provisions of the Texas Constitution. The proceeding is being broadcast over the court's YouTube channel. Because of that, it is entirely possible that someone with more technical expertise than I could pull off a video file off YouTube or off Zoom and create your own backdoor recording of this proceeding. Because this is a proceeding in a district court of the state of Texas and no order has been entered authorizing video recording of this proceeding, I'm here to advise that there is to be no recording of this proceeding. There is one record and one record only that comes out of proceedings in the 95th District Court, and that is the record maintained by the official court reporter of the 95th, Ms. Rouse, who is here and who will report today's proceeding. This is DC 20-08815 Myrta, M-I-R-T-A, M. Oseguera versus Reader Real Estate LP and CR Property Wise LLC. And I have counsel state your names and who you represent for the record.
Ian Greist for Reader Real Estate LP.
Julia Wanacott for defendant CR Property Wise LLC.
Anthony Clarkson for Mirta Arceguera.
And Mr. Cartwright, are you here on this one or are you here on the next one?
If the next one, Your Honor, is DC 19-18966, that's what I'm here for. So I'm going to put myself on mute and close my video.
Sure on that. Yes, that would be our hearing at 2 o'clock.
Gotcha. My notice said 1:30, so that's why I showed up.
Well, we start the afternoon docket at 1:30, but the hearing I think was noticed to be at 2 o'clock, even though I'm on the bench starting at 1:30. So gotcha. That's why.
Okay. In that case, I'll just listen in.
All right, very good.
Anybody.
Thank you. Okay, Mr. Clarkson.
Yes, Your Honor.
I'll just start with you. I've read only one of the motions to compel. I wasn't aware that there were two set, but fair enough. Is there a reason that your client has not responded to the discovery requests?
The discovery requests were responded to Mr. Greist via certified mail return receipt. In talking with my postal carrier during the multiple evacuations we had on Galveston Island throughout the time, apparently there was a lot of issues with certified mail. Not so much the regular mail, but certified mail as far as getting set aside, not transporting, etc. I did receive the green card from that delivery back this week at my office. As far as with Miss Wanacott, that was a complete oversight on my part. She had filed her discovery request timely, and she was gracious enough to give me additional time until the 23rd for mailing. That was mailed out same way on the 23rd, and I just had not followed through with her request for the digital copies until this morning, to which I followed that up with those as well. So with Ms. Wanacott, that was definitely in relation to just my overlook The one with Grice was a mail issue regarding the Galveston Postal Service, but it has been rectified.
Mr. Grice, have you received plaintiff's responses?
Yes, on Monday of this week, I received responses and I've been reviewing them. The responses state that they were mailed on September 4th, but they were received on Monday. I ran the tracking number on the USPS website and it did not say when they were actually mailed. I don't see how it could take nearly 2 months, but basically my complaint is that I requested that they be produced digitally under Rule 194.4. The request can state a reasonable time and place for production, and then that has to be complied with unless there's a objection, and there was no objection. I asked multiple times for digital copies of those records. I never got them. The records that I did get were very evasive and incomplete, but I believe I'll need to file a separate motion related to that. I've only had a couple days to look through them, and I'm not quite prepared to file a motion with whatever the specific complaints that I do have with what I did receive. The only remaining, oh, sorry, go ahead.
Do I need to enter an order compelling production on those, or you've got them?
I do have them.
All right.
The only
Ms. Wanacott, have you received your client's response? Let me rephrase that. Have you received plaintiff's responses to your discovery?
Yes, we received, well, I should say yes in part. We received the responses to requests for production this morning. However, we also had propounded requests for disclosures. We still have not received responses to those. Our request was submitted in our answer. And so yes to the request for production, no as to the request for disclosure. And also, Your Honor, in our motion, we sought, part of the relief we requested was that the objections, that they produce discovery without objection. The responses I received this morning had a litany of objections. So we would urge our motion to the extent we've asked the court to compel Mr. Clarkson to provide us with discovery without objections.
Okay.
I'm asking for the same thing, to strike the objections as being untimely.
Mr. Clarkson?
I will disagree with that wholeheartedly because according to the rules, the answers were provided via certified mail, postmarked September 4th, in compliance with the 2-week extension granted. And Mr. Grice's request for admissions and everything, Your Honor, just to put into perspective, obviously his request for production, admissions, and everything were trying to take advantage of the fact that my client was pro se at the time when all of these were exchanged. That was the whole purpose of me getting an extension to start with, is because I had just come in. Many of his requests for admissions require expert opinions and legal conclusions in order to establish parts of a case, like asking what is basically admit that the fair property value of your home is over $100,000. Admit that you had a reasonable rent. My clients would not be able to admit or deny those type of questions. So not only
Mr. Clarkson, your client specifically says what the value of the property is in her petition.
Exactly. But to say that, but to admit that that you received a reasonable rent is not a proper question for a request for admission. That requires expert testimony or at least discovery.
I'm not hearing that today because that wasn't the subject of the motion from what I understand. But I'll make this observation. I don't know what day they were mailed. I don't know what the postmark shows.
The postmark shows September 4th.
I don't know if there's even a postmark, but I will say this. We have e-service through the Texas e-filing, which eliminates all these issues entirely.
I understand that, Your Honor, but that's not the requirement. That's
It is
my
not
only
a
offer.
requirement, but it
Oh,
it does seem odd that something would be mailed September 4 and arrive on November the 30th. So
I think it is a requirement because Rule 194.4 states you have to comply with the method requested unless it's objected to, and it was not objected to, and I requested electronic. But I understand, the issue.
okay, Ms. Wanacott, I will sign the order that you have tendered requiring production of requiring service of the responses of plaintiff to your client's request for production within 7 days of the date of the order, which is today. And I'm signing it as of today. And Mr. Greist, I'm willing to sign some aspects of your order. I'm thinking there's some of it you would rather me maybe not sign, and suggest that maybe that might be better handled in a subsequent motion if you have any complaints about what you received on Monday.
I understand the top paragraph is unnecessary.
I mean, if you want to send me a more direct order, like without some of that stuff on there, I will consider it.
Understood.
All right, but the motions to compel are granted, but it looks like they were answered to. So now we can deal with what else is there. Do y'all have a moment to talk? Can we go off the record? I mean, are y'all
Agreed.
willing to have a discussion here?
Yes.
Yes, Ron.
Then let's go off the record and turn off the YouTube for a moment.
Yes, sir.